Representative Allemand?
Present.
Representative Angelos?
Here.
Representative Haroldson?
Here.
Representative Pendergraft?
Excused?
Representative Sherwood?
Here.
Representative Smith?
Here.
Chairman Bear?
Here.
Mr. Chairman, you have a quorum.
Thank you. Representative Harrelson, would you please lead us in a word of prayer? And Representative Allen, would you please lead us in the pledge after that?
Dear Heavenly Father, we thank you so much for the opportunity we have to be here today, God, as we're coming to the end of this session and we get tired and the body gets weak. God, I pray that today we would lean into you. We'd realize that our strength doesn't come from ourselves, and when it does, it's flawed. So God, I pray as we make decisions today, as we carry ourselves through the rest of this day, God, I pray that we would do it in your strength, understanding that we're here for the people and we're here by the people. And God, I pray that we would understand that we're here to do the people's will. Pray you bless the time and the conversations and the decisions being made today. We pray these things in Jesus' name, amen. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all, born and unborn.
Thank you. Everyone, welcome to House Appropriations. We are going to quickly dispatch a re-referral, and then we're going to get into the meat of today's work, which is Senate File 196, Second Amendment Protection Act amendments. So initially here, we're going to start with Senate File 187, Public Employee Retirement Plan Contributions. This was brought by Senator Hicks. You can see it's on white paper, so we don't have any amendments in the Senate, or I don't think we have any amendments from the original committee either. Can one of you all confirm that for me? Is there anyone here to present or discuss Senate File 187? Seeing none, we'll just do this, work this as a committee. I'll close public comment on Senate File 187. All right, and I'm assuming we have no one online for that? Okay. All right. So anybody finds that where there's been an amendment in the Committee of Origin in the second house, let me know. But I'm just going to work on this here right quick. This bill has to do the public and...
Mr. Chairman?
Go ahead.
There are
Representative Haroldson.
There are none.
Are no amendments. Very good. Thank you. Just confirming that. All right. So this is titled Public Employee Retirement Plan Contributions, an act relating to public employee retirement, increasing the employer-employee contributions for public employee retirement plan. And we'll go over to the fiscal note, which will not have changed based on the lack of amendments. Contains an appropriation for $1.741.5 million from the general fund to the state auditor. Also contains an appropriation of $3.4 million from the Public School Foundation program account to the state auditor. So it's for contributions for the retirement plan. Any discussion? Representative Sherwood, please.
I guess, thank you, Mr. Chairman, and good morning. Just as a backstory, this is a topic that the Appropriations Committee had on its docket 2 interims ago. And so I know that we made some adjustments there and had really great feedback from the department that oversees our retirements. And so kind of, I'm scratching my head a little bit about
Why it's being revisited?
Yes, Mr. Chairman, why it's being revisited. Anytime I see just one sponsor on a bill, it's sort of a red flag for me. And then to not see that sponsor here and to not see the agency overseeing the retirement here to give us some context, I guess I have some pause. Thank you.
Okay. Representative Alman?
Thank you, Mr. Chairman. Is this stuff we're obligated to?
So the question is this stuff we're obligated to? We do have obligations within the retirement system. Since we don't have any testimony as to why this increase is coming, I cannot answer whether we're obligated to this particular expenditure or not. So my recommendation would be, if you're not comfortable with it, that you vote do not pass. We'll get with the sponsor and And when it comes to the floor, we can have that discussion. We are the second committee, and this was voted, approved by the primary committee. I think that was corporations, am I correct?
Mr.
Representative
Chairman?
Smith.
Yeah, it looks like it was labor,
Labor Health. Okay. Probably that would be appropriate.
and then it was a 4-3-2 vote.
432, okay, thank you. 4-3, probably, yeah, 432, that's right. Representative
So
Harrelson.
just real quick, looking at it, the change we're seeing is on page 2, line 1, we're seeing a 9.25% from July 1st, 2021 through June 30th, 2026. That would strike that 26 and go 2025, and then we change that to 9.5%. And so that would be for the member contributions, payroll deductions. So that would be, sorry, I'm learning as we're rolling right now. So it'd be basically a 0.25% increase there. Down below on the next section, we go from 9.37 to 9.62. So just right in that same ballpark. So basically, they're just doing, it almost looks like somewhat of a inflationary increase or a cost of, I mean, I know we're not gonna call it a COLA because we don't do that, but it's kind of what it looks like, is just a increase. So, I don't know, that's just,
So my understanding when I read this was that was each employer extending employers of firefighters shall on a monthly basis. Initially, I thought that was the employee, but it is the employer, so that's why we're on the hook for that. Okay?
Yep.
So you could disagree with Labor Health's concurrence on this if you wanted, if you chose to, but that's what it's being applied to. Thank you for that, Representative Harrelson. Any further discussion on the bill? Okay, committee, what's your pleasure?
Mr. Chairman,
Representative Harrelson.
let's move do not pass.
Well, I would recommend move do pass.
Okay.
And suggest a no vote,
Okay. Move do pass and suggest a no vote.
okay?
I'll second that.
All right. So this is move do pass. Ms. Childress, please take the roll.
Roll call vote, Senate File 187, do pass. Representative Allemand?
No.
Representative Angelos? No. Representative Haroldson?
No?
Representative Pendergraph excused. Representative Sherwood?
No.
Representative Smith?
No.
Chairman Bear?
No.
Mr. Chairman, 6 no, 1 excused.
Okay, that is second committee's action on there, so that will be on the record as a no vote from the Appropriations Committee. And we'll see that on the floor. Let's get some more information from the sponsor so we can speak to it, why we voted no. Okay? All right, that's dispatched. Senator Salazar, the good Vice President, please come forward. Welcome to House Appropriations. We're excited to work on the Second Amendment Protection Act amendments. We had a discussion earlier, just for the record. I have some concerns about the bill, but I want to get those concerns dispatched before we move the bill out of committee. And should that delay, I'm going to make every effort to ensure that this bill makes the timeline, and if there's a veto, we'll make a timeline where the body can override that. So I made that commitment, and now it's on the record. So welcome here, Mr. Dorr and Senator Salazar, appreciate you. If you guys could just present the bill to us, we'll get started.
Thank you, Mr. Chairman, honorable members. So what you have before you is the Second Amendment Protection Act, Senate File 196. And very briefly, the summary of this bill is, and I know that you've read it, is that Senate File 196 seeks to amend Wyoming's Second Amendment Protection Act by prohibiting state and local government entities from enforcing or assisting in the enforcement of certain federal firearm regulations deemed unconstitutional. The bill establishes civil and criminal penalties for violations and ensures that state resources are not used to enforce federal gun control measures that infringe on Second Amendment rights in Wyoming. The key provisions of this bill is that, again, it prohibits Wyoming government entities from using state funds or resources to enforce federal firearm laws that violate state Wyoming law. Number two, it imposes a $50,000 civil penalty per violation against agencies, not against individual law enforcement officers, but against agencies or political subdivisions that assist in enforcing such laws. It exempts state officers from penalties when assisting in criminal investigations that have a clear nexus outside Wyoming or involve serious crimes. And the bill also defines terms such as law-abiding citizens and material aid to provide clarity on enforcement. It reaffirms Wyoming's authority to uphold the rights of its own citizens, independent of federal overreach. It ensures the state, counties, and municipalities cannot be compelled to enforce federal gun control measures, contrary to the laws of Wyoming. It protects Wyoming gun owners from federal laws that may conflict with the Second Amendment. It strengthens legal protections for law-abiding gun owners within Wyoming. It prevents state agencies from taking part in unconstitutional firearm confiscations or restrictions. It establishes a clear legal pathway for citizens to challenge wrongful enforcement of federal gun laws, and ensures that Wyoming residents are not unfairly targeted by federal overreach. That, in a nutshell, Mr. Chairman, is the bill. I believe that this bill is non-controversial. I've listened to gun groups and their concerns and tried to adopt their needs into this bill. It does protect individual officers, and it does protect gun owners, I believe, in this bill. Finally, the Senate File 196 is an update of the current SEPA bill that we passed in 2023 and makes it stronger. I'm sorry, in 2022. And with that, Mr. Chairman, I'll ask Mr. Dorr to make some comments and stand for any questions.
Before we do, are there any questions for the bringer of the bill? Representative Smith.
Thank you, Mr. Chairman. Can you just go over some of the points that make this, you mentioned that we had a SEPA in 2022. What specifically is in this one that's different than the one that we've already passed?
Senator, I'm going to ask that you just be general, and I think we're going to get into more details when Mr. Dorr gives his testimony. So I don't want you to have to do that. And I'm going to just be very transparent here. We're at crunch time right now in the bodies, getting bills out before we end up with an inability to do veto overrides. So there's a lot of stuff going on outside of this work we're going to do in this committee on this bill. And the good vice president is involved with a lot of that work. So I don't want anybody here in the committee or the public to think, I have excused him from being here for the entirety of our work because he needs to get other work done. And I don't want anybody to think that he is not invested in this bill. So that is clear, an agreement that I have with the good senator. So sorry to have to take some time and describe that, but I want everybody to approach this correctly. And I want the public to understand what's going on here. So with that having been said, please just a general explanation of the differences between the 2022 SAPA and this bill here.
Thank you, Mr. Chairman. So Representative Smith, the primary difference between the 2022 bill and this is civil penalties. That is the primary difference. It's strengthening the help of individual citizens who can bring that if in fact the federal government was to perform confiscation or overreaches. It allows that civil penalty for citizens to go into a court and defend themselves in a civil manner. That is the primary difference.
Okay. Further questions for the bringer before we move on? I want to make a comment here to the good bringer of the bill. You commented that this is a compromise where you've got various gun groups that have come together on this, and I want to tell you that I appreciate that. This is probably this is different from what we've seen in the past. I think we've got some angst within agencies, and they have some concern, but we're going to work through that as we work this bill. I think that's all completely workable. And I appreciate your effort to do just what you said you did and get a good compromise. So with that, before I let the good senator go, is there any further questions for the senator? Senator, you're welcome to stay, but if you've got other things to do, we will not hold it against you that you need to get on to do those things.
Thank you, Mr. Chairman, and obviously we have the floor manager, if this bill were passes, Representative Worf, and then obviously Aaron Dorr will be here as well.
Okay.
Thank you.
And I assume, I'm making an assumption, but I think Representative Worf has a good, solid understanding of the bill. Okay.
He does. Thank you, Mr. Chairman. Thank you, members.
Thank you, Senator. We appreciate you. Okay. Mr. Dorr.
Mr. Chairman, members of the committee, thank you for your time today. Aaron Dorr, on behalf of the members of Wyoming gun owners, we're in full support of SF 196. We'd ask you to move it as quickly as possible. This has been a long conversation in this building. It's been going on now for about 4 or 5 years, and we believe this bill will kind of fix all of the issues that exist in our current SAPA law and give real clarity to gun owners and to members of law enforcement. I'm going to give you a deep dive on the bill. I'll try to be brief given your time constraints, but I am going to dig into some of the details to answer some questions that members may have about what the bill actually does. I want to begin with the basic definition. It's a lot of words in this bill. What does SAPA actually mean? Second Amendment Preservation Act simply says that Wyoming cops will enforce Wyoming laws when it comes to firearms, ammunition, and accessories. And what that means is the federal government cannot compel Wyoming cops to enforce any federal gun control laws. This issue came up under the previous administration, as you could imagine. And the question has come up, why do we need this now? We have a new administration, so why do we need to have this now? That's a two-part answer. Number one, we only have President Trump for 4 more years. And number two, having a friendly administration means that if this becomes law, it will likely not be challenged in court the way that other states' SAPA laws were under the previous administration. So now is a good time to get this accomplished. This bill does 5 specific things. I'm going to break them down for you in order of the bill to kind of keep it sequential for you. On page 3, lines 16 and 17, we deal with a problem that kind of happened in the 2022 version of SAPA. That law said that Wyoming cops could not enforce any federal gun control laws if they were funded with monies that originated with the state of Wyoming. And the problem that created then was when a federal task force is created, and they'll bring up ATF or FBI from Denver, and they'll grab some deputies, a couple city cops, and a couple troopers, they're then being paid for with federal money. And because of that, then they're allowed to enforce federal gun control laws because they can get around the current SAPA law, which only makes it a problem if they're paid for using state dollars. So we deal with that, again, on page 3, lines 16 and 17. On page 3, line 18 through 22, we deal with a problem that was also kind of happened in 2022. Line 20, the word unconstitutional is struck. So SAPA law in 2022 barred the enforcement of unconstitutional federal gun laws, but there was virtually no definition of what unconstitutional meant. And so it leaves lack of clarity for gun owners and for members of law enforcement. What can we exactly do? What we have done with this legislation is made it very clear on lines 21, well, it begins at line 20 through 22, that all federal acts, laws, treaties, orders, rules, and regulations from the federal government on the topic of guns shall not be enforced by Wyoming law enforcement. So it provides, we believe, clarity to gun owners and to our members. On page 4, line 10 through 12, we clean up some language also from 2022. That law said that nothing, this is a paraphrase, I'm not reading verbatim from that law, but it said nothing in this section shall preclude Wyoming from receiving federal dollars to enforce federal laws. But that was kind of a circular reasoning. It kind of caused problems because we don't want Wyoming cops to enforce federal gun control laws. We have clarified that with this. As you can see on line 11 and 12, that Wyoming can receive assistance, funds, or other assistance from the government to enforce the laws in this state, line 12 on the bill. So it gives real clarity on what we can and cannot do. That's the third issue. The fourth section, page 4, lines 16 and 17, specifically line 16, we add the word peace officer into the law. So when SAPA passed in 2022, the penalties were only ascribed against public officers. In Wyoming, a public officer is one whose office originates with the state constitution. So you all are public officers. The governor is a public officer. By not mentioning peace officers, there was no real way for a gun owner whose rights were violated to have any way to hold them accountable. And so we have added peace officer in here on line 16. Now, I want to be clear. I'm going to hit this 2 or 3 times, Mr. Chairman. We say peace officer, but we're not assigning penalties to the peace officer. We have to define them for purposes of the penalty, but that goes against the agency, not the individual officers. So I just want to get that clarified. There is a typo that I drew the attention to this to Representative Haroldson. He's going to deal with this, I believe, in an amendment, line 15. The word employs is got an extra E in there, so I think we can deal with that later with an amendment. But I want to draw your attention to that, Mr. Chairman. And from there, bottom of page 4 through most all of page 5 is the introduction of civil penalties. These are shall issue penalties. That's page 5, line 5. If you look down at page 6, against the agency, subdivision, or law enforcement agency, not against individual law enforcement officers. In the other chamber, there was some requests from law enforcement to give some clarification on some issues, and we have dealt with that. If you want to skip ahead, I promise that's going to be sequential. I guess I lied to you. Page 8, we have some clarification. I guess you're going to call it belt and suspenders from law enforcement. Page 8, lines 6 through 8, makes it clear in black and white that nothing in this bill shall preclude Wyoming cops from seizing firearms related to an investigation of a violation of Wyoming law. So we're just being abundantly clear that Wyoming cops can seize firearms as part of an investigation to an alleged violation of Wyoming law. We again say on that page, line 10 through 12, no civil penalties can be assigned to individual public officers or peace officers. That's line 11 and line 12. Couple carve-outs, so to speak, on this bill, Mr. Chairman. If you go to page 7, this is pretty much the end of the bill. Page 7, it's been asked a couple times, who does SAPA not apply to? And when we kind of clear on this, number 1, lines 5 through 9 spell out the fact that SAPA only applies to law-abiding residents of the state of Wyoming. So if people ask me specifically, can we help, for example, the president if he wants to deport foreign nationals from our state if they have firearms? Yes, you can, because they are not law-abiding residents of the state of Wyoming. It also applies to anybody else who is not a Wyoming citizen. This is a Wyoming bill for Wyoming gun owners, for Wyoming cops, Wyoming citizens. So that's one carve-out, so to speak. Later on, page 7 still, line 11 through the first part of line 13 makes it clear that it's not a violation of SAPA law for Wyoming cops to help the feds arrest or detain somebody, even if that person has a firearm, if it involves a case of felony controlled substances. So if they're distributing of narcotics, for example, that would still be allowed for Wyoming cops to detain somebody. The example would be a truckload of fentanyl coming out of Denver on I-25. The feds are tracking the vehicle. They ask for help to detain that vehicle. There's a gun involved. That's okay, because the underlying issue was narcotics, and the gun is, as you see on line 16, ancillary to the prosecution. The next example, or carve out, so to speak, would be any felony crime against another person, line 13. So if the feds are tracking somebody who is a murder suspect, or who had committed a heinous, violent felony crime against a person, sexual assault, for example, and he happens to have a gun, that's okay. Wyoming cops could still, of course, we want them, of course, to detain that person, arrest that person, hold that person for federal law enforcement. Final point of clarification, Mr. Chairman, page 7, line 18 and 19, just again clarifying that Wyoming may receive federal assistance for the enforcement of the laws of this state. And that's not just financial, that's everything. That's databases, that's queries, that's manpower, that's all of it. We're not cutting off help from the federal government. We're just simply saying when it comes to firearms, we're not going to let Wyoming cops help them enforce federal gun control in this state. And I believe, Mr. Chairman, that would be the end of it. I guess all I would say in conclusion, Mr. Chairman, is that we've heard from law enforcement in the other chamber, and you may hear from them today, various scenarios. And I just want to clarify, just to make it abundantly clear, every bit of Wyoming law is to be enforced by Wyoming law enforcement. That has not changed with SAPA. So every single crime that's a crime today on the books will still be able to be enforced by Wyoming cops. All federal laws, all of them, except for firearms enforcement will still be able to be enforced by Wyoming law enforcement. This is narrowly tailored to preclude the feds from not using Wyoming cops to enforce federal gun control laws. With that, I'll stand for any questions.
Okay, questions for Mr. Dorr? Representative Sherwood?
Thank you very much. Thank you for your testimony. I just want to make sure that I'm understanding the difference between when it applies to an agency and when it applies to an individual.
Yes, ma'am.
So on page 6 of the bill that talks about any agency, I guess I'd also like some explanation of like, where did the 50,000 for each such employee of the agency come from? And I'm thinking of things like our highway patrol is under our YDOT agency that has, oh my God, I don't even know how many hundreds of employees, right? So is there a limit for when you can say 50,000 for each such employee when it's in an agency with hundreds of employees? So that's one question about when it applies to an agency. And then when you flip over to page 7, starting on line 21, I believe the Senate added this. So this is then an officer who knowingly violates. So I assume this again relates to an individual. Flipping over top of page 8, it talks about imprisonment for not more than a year and then a fine of not more than $2,000. So am I clear in understanding that there are both penalties for an agency and penalties for individuals in this bill? Thank you.
Mr. Dorr?
Mr. Chairman, thank you for the question. So there's a little bit of that's a good question to get clarification on. I'll answer the easiest one first. On page 7, line 21 through 23, and it continues on to page 8. Let me turn there. Lines 1 through 2, that is actually existing code in Wyoming. That was part of SEPA from 2022. So the criminal penalties are existing law. And the original version of this bill removed the criminal penalties. They were reinstated via amendment in the other chamber, but only to keep it in compliance with current existing law. And so that is current law that's not being added to the bill. As far as the penalties go, think of this as 2 tracks. If you're the gun owner, and your front door is kicked in, and you have law enforcement that violates SEPA to enforce a federal gun control law, you then are the victim, and you can sue that individual agency, not the agent or the individual officer, for damages. That begins on the bottom of page 4, and it goes all the way through page 5. Page 6 is a different situation. What we're trying to deal with here is a problem we've had in various states where law enforcement, let's just take Cheyenne PD. We're sitting in Cheyenne right now. So we have Cheyenne, I think, PD in the room right now. So Cheyenne PD has a department, and they loan out, let's say, 4 or 5 officers to a joint federal task force. If they do that, that would be lawful, because we're not limiting, the states cannot limit what the feds can do in enforcing federal gun control laws. The problem page 6 seeks to address is basically badge swapping, where one day an officer is Cheyenne PD, which means he could not enforce federal gun control laws. The next day, he could be U.S. Marshals or ATF or FBI via a task force. And what we're trying to avoid with page 6 is where an officer jumps departments, not that it happens daily, but jumps back and forth, because if they're under the authority of their Cheyenne Police Department badge, they could not enforce federal gun control. If they're under the authority of an ATF badge, then they could. And so what page 6 says is that any public officer who has knowingly committed a violation of this act after July 1st of this year, that agency shall be liable for employing that individual. And that's a separate situation we're trying to address versus you're the gun owner and your guns are taken away in a midnight raid. I hope that provides some clarity, Mr. Chairman.
Follow up? Representative Angelos.
Thank you, Mr. Chairman. Mr. Dorr, is badge swapping happening in the state of Wyoming?
It happens on a frequent basis, and we heard testimony on this fact in the committee chamber, on the other chamber last, I guess it was 2 weeks ago, where we have officers that will be a part of various task forces, and we want to make sure that we don't have a problem where that is allowed to in some way circumvent the idea behind SEPA.
Further questions for Mr. Dorr? I'd like to revisit page 6, your last answer there about those who have done the badge swapping. And I'm specifically looking at the language on page 6, line 4, where we talk about a peace officer who previously acted as an official agent, employee, or deputy of the United States government and who knowingly commits. So my understanding, and correct me if I'm wrong, is that this statute would apply to somebody who has done badge swapping and has violated this statute.
Only after the implementation of this, it's not in there, it doesn't look backwards.
Right.
Yes.
No jeopardy before its implementation. But yeah, if they were, just to be clear, if they were badge swapping, they would be caught into this and said, okay, if you knowingly did this, even if you were wearing a badge for the feds, you're in violation.
Then the agency would be in violation by employing that officer, not the individual officer. Yes, Mr. Chairman.
Okay, so it's going to put that agency at civil risk, if you will, for letting that swapping going on, having that swapping going on. Okay, and I don't know, did you get an answer for the number of employees? I think the answer that you're looking for is it's based on violations. So however many employees violate, that's how many $50,000 fines could be assessed. Is that an accurate?
Mr. Chairman, so the answer is no, I guess, Mr. Chairman. So if you're the gun owner and your rights were violated, you could sue that department for $50,000 for the violation. That's the penalties for that violation. The other page, page 6, deals with the employment of people who have been swapping jurisdictions, let's say, and then for each individual officer who has been doing that, the department is liable for those damages times each officer who has done that. So if it's one officer, the department is liable for $50,000. If 10 officers have been jumping back and forth, they're liable for $500,000. But it's based on the officers, the number of officers who have done this violation.
So Mr. Dorr, who would be capable of bringing that suit? Is that just any citizen could bring that suit, or would it have to be a citizen whose rights were violated?
With regards to the first, if you're the gun owner whose door is kicked in, to use that verbiage,
obviously.
that you have status there, and anybody could sue over this violation, but the penalties remain $50,000. So if I'm reading the chairman's mind, maybe I shouldn't be trying to do that. If 50,000 people file a lawsuit over this violation, they could get $1 each, if that answers your question.
Okay. All right. Representative Sherwood.
Thank you, Mr. Chairman. As a follow-up, I still think the language could use some tightening here, but through the dialogue and the conversation, I guess another question arose. One, I'd never even heard of badge swapping, so I'm learning something new today. But do you think that this language here and the scenario we're talking about will make our state agencies less likely to hire somebody with federal law enforcement experience? So if we have a shortage of officers in our state, they're working their butts off, they're covering a lot of ground, right?
Sure.
And then we have openings in our agency. I know we have a lot of openings in, again, highway patrol. Will there be a red flag to say like, oh, I see on your resume that you were previously an agent, employee, deputy of the United States government? That then presents some liability to that agency in hiring that person.
Mr. Dorr.
Mr. Chairman, so the answer is maybe and no. There's no liability to the agency who hires a former federal officer, none. The only liability comes into play after the implementation of this act, and only if that officer would then change jurisdictions and violate state law by enforcing federal gun control laws. There's no blanket prohibition on hiring former federal officers at all. And as far as your first question, as far as does it chill the hiring of federal law enforcement, I guess my answer would be I don't believe so. I've talked to a number of law enforcement officers, and you might hear different testimony here today, but from a lot of the frontline cops that I have spoken to and sheriffs who have reached out who don't want to necessarily be here in a committee today, they are very comfortable with having penalties. They're very comfortable with knowing that we don't want to enforce federal gun control laws. I don't want my officers to enforce federal gun control laws. And so for the most part, we don't believe there's going to be a chilling effect because most of these agencies want members on their departments who want to uphold the Constitution and don't want to enforce federal gun control laws. So I don't think it's going to be that big of a problem for the majority, if not the bulk of Wyoming.
Representative Smith.
Thank you, Mr. Chairman. Mr. Dorr, so from what I'm understanding, this only allows individuals to go after state employees or state agencies. It does not allow them to go after federal agencies that may be in violation themselves.
I'm going to be real careful here. You know, it's clear that this doesn't go after individuals whatsoever.
Okay,
Let's,
okay. Yeah,
all of our
any
language,
federal
let's
agencies.
make sure we support the bringer of the bill in that regard.
Yeah.
But the question, if you narrow that question down to federal versus state, please answer the question.
Mr. Chairman, thank you for the question. Yes, it would be a supremacy clause violation for Wyoming to try to bring suit against the federal government for enforcing federal gun control laws in the state. And similarly, it would be a lack of standing, and it would not survive a court challenge for a citizen to bring a suit against the federal government for enforcing federal gun control laws. I'm not saying I necessarily agree with that as far as my long-term goal for the Second Amendment, but here and today, certainly it would be a supremacy clause violation to do that. So no, there would be no status in this bill for a Wyoming citizen or subdivision or anybody else to file a suit against the federal government for the enforcement of federal laws.
Further questions for Mr. Dorr? Okay. Mr. Dorr, thank you. I hope you can stick around throughout the testimony. We may have follow-up questions and bring you forward for those. I appreciate your work on the bill as well.
Thank you, Mr. Chairman.
If you could just stay there, we may have questions for you, Representative Wharf, but I'm going to let our legal team come up right now because they need to get back to the pit and help the senators with their stuff. But if you, our attorneys could come forward, I've got some questions specifically for them. And I'm not sure they're going to be able to answer all my questions, so we may need some more testimony later. Welcome, Mr. Fuller, to Appropriations. Ms. Hanson, appreciate you being here. Okay, so this line of questioning that I'm going to bring comes from my conversations with my sheriff. As I read the bill, and I'll just be completely open here, there was an amendment brought that I found unfriendly to the bill. As I read the bill, I didn't think that the amendment was necessary. The issue at hand in this question is, does this bill preclude our law enforcement, our state law enforcement agents from working with federal agencies to enforce ICE, be on a task force with ICE to enforce border security laws, DEA for drug enforcement, human trafficking, all these other things that an agency, one of our agencies might work with a federal agency in order to enforce those laws. Do they end up in violation of this law? And will this have a chilling effect on their working with those federal agencies on those matters based on this bill? And so as I look at it, and I'll take the committee and the public to page 4, at the top of page 4, my conversation is centered around the word solely on line 2. So my interpretation of this bill initially, and I think I've been corrected by the drafter of the bill, was that as long as that agency was not solely working on an issue that was regarding firearms, accessories, ammunition against a law-abiding citizen, which is defined in the bill, then they were not in violation of this law. And I felt like solely, the word solely meant that they probably wouldn't be working with the BATF, which generally solely works on these issues. But if they were working with ICE or DEA or one of those other agencies dealing with these other issues and a firearms violation occurred, then they would still be protected from being liable in this bill. I think I'll turn to the attorneys now and get their interpretation. I've since been corrected in that assumption. So the word solely actually does apply to page 3, line 20, and 21 and 22. So the word solely is applying to any act, law, treaty, executive order, rule, or regulation of the United States government that solely regarding firearms, accessories, ammunition against any law-abiding citizen. So am I clear as mud now with everybody? And Mr. Fuller, I think that was your interpretation of the word solely as well.
Yeah, Mr. Chairman, I think that's right. The way it's drafted, it's arguable that solely would modify the act and those terms, laws, treaties, and so forth.
Okay. Ms. Hanson, any additional information from your perspective? Okay. All right, so just to help the committee and the public understand this, this means that our police forces, our sheriff's deputies, could not be involved if a federal gun law was used in their line of work. So in other words, if they're enforcing federal law dealing with border security, drug enforcement, human trafficking, that's fine. But as soon as the individual who has to be a law-abiding citizen by definition of this, so they can legally own a firearm in the state of Wyoming, as soon as a federal gun charge is attached, then it's potentially a violation of this bill. And it's important to look at Mr. Doerr's testimony about the lanes. And I'll take you to page 4, lines 11 and 12. The enforcement of laws in this state, that's our lane. That's the lane that if they're in that lane, if our enforcement agencies are in that lane where they're enforcing a state gun law, then they're not in violation. It's also found on page 8. Lines 7 and 8, related to violations of Wyoming law. So I have some concerns about that, and we're going to try to get to the bottom of it before we pass this bill out, so we can make sure this works both for our citizens who might have their Second Amendment rights violated, but also for our law enforcement agencies. So the way I see this is that and I apologize to everybody in the room that I'm opining so much, but I would hope that the drafter of the bill would come forward and correct any statements that might be wrong here. Our law enforcement agents, if the task force attempts to prosecute an individual for a federal gun law, they'll be in violation of this bill. If in turn they enforce a federal human trafficking law and a state gun law, they would not be in violation of this law. I see you shaking your head. Mr. Doerr, is that please come forward, Mr. Doerr. Would you like to opine on that comment, please?
Well, I want to opine, sir, but I'll try to be brief. I actually agree with Ledge Counsel that it could be argued. I disagree that there's a problem. I'll just get that said right off the get-go.
Sure.
And how I would answer that, Mr. Chairman, is just for clarification, just for some general clarification, page 4, line 5 through line 8, and this is not directly to your question, but certainly is related to it. Nothing in this act shall limit or restrict a public officer from providing assistance to the federal authorities for purposes not specifically identified in subsection A of this section. So right off the get-go, any other violations they can help the federal authorities enforce. They can also detain anybody in the state for a violation of state law. They can also detain anybody in the state on the request of federal authorities who think they have done a felony narcotics or persons crime, even if guns are involved. And as to your question, Mr. Chairman, I don't believe that they would be in any violation because let's just say that they detain that vehicle with fentanyl coming out of Colorado. So they can detain them for the feds. The feds can take over that prosecution and prosecute the narcotics and the firearms. Alternatively, Wyoming could prosecute for the narcotics and simply not prosecute for the firearm and give that to the feds to prosecute. So there's various avenues for these cases to be prosecuted, and I do not believe that we're causing a conflict here with the current language.
Okay. Mr. Fuller, I would like your take on that. And here's the issue that I would see is an individual is detained by a Wyoming law enforcement agent for a federal drug law violation. They are picked up. There's an ancillary gun issue. That individual is picked up by the feds and then prosecuted by the feds for both their drug violation and their firearms violation, but via a federal law. Does that individual now have, if this bill were to pass, a right to sue that the initial detaining officer's agency because later on a federal gun charge was prosecuted. Do you grasp the question well enough that you could do some research and answer that at a later time?
So, Mr. Chairman, perhaps, I think, the question is, what did the officer do? Really, to me, it seems like the question is, what did the officer arrest the person for? Because that is the enforcement of the law versus what the person was prosecuted for, which is a decision made later on by, a prosecuting attorney, whether that be, a district attorney, representing the state of Wyoming, or an assistant U.S. attorney representing the United States. So I think the question would be, for what did the detaining officer arrest or detain that person for? That is the enforcement of the law at that point.
I'm looking for it right now, and I think you've cleared it up for me. There's a language about in the exceptions about ancillary. Page 7, line 16, thank you. Such weapons violations are ancillary to such prosecution. Okay, so I think we have it now. I think we're protecting our agents based on both that language, your interpretation of that language, and the exception on page 7, lines 11 through 16. Okay, thank you. I think for now, I had one more question for you guys, and that has to do with this bringing in the language on page 7, line 22. There's been some debate between gun agents or pro-gun lobbies about this public officer. It was testimony here was that a public officer is basically an elected official. The way I read this, it's referring to this language. Public officer means a person who holds an office which is created or granted authority by the Constitution or legislature and who exercises a portion of the sovereign power of the state. Now that's pretty open language. I just want your two opinions about who's all pulled into that definition.
Yeah, and Mr. Chairman, that, I would need to look at that definition. I think we would need to look more closely. Based on what you read, though, arguably peace officers could be included. I mean, they are exercising authority on behalf of the state of Wyoming.
Okay. Well, the bill brings in peace officers, so I think the language tightens it up anyway. So I'd just like to have that answer. We can take that offline, just if you can get that answer for me. Who all is wrapped up in that definition? I'd appreciate that. All right, any questions for the attorney staff? Seeing none, you guys are welcome to take off. Appreciate your help on this, all right? Okay, Representative Wharf, would you like to testify on behalf of this bill?
Yeah, thank you, Mr. Chairman. I guess, there's been a lot said. The thing that I would like the committee to take home from this is the whole purpose of this is to protect law-abiding citizens and our Wyoming law enforcement guys. I know I kind of played a little bit being law enforcement, and I know one of the things that would be very chilling to my friends that I know that are in law enforcement is if they were given an order to go start seizing firearms. That's what this does in my mind, is it protects our guys from being given a directive that really could be life-threatening to them. Because I know I wouldn't want to be the guy knocking on doors saying, I'm here to take your guns. And that's really, to me, in a nutshell, what this does. This doesn't impede anything else. When the issue you brought up, Mr. Chairman, to me, I looked at that the way I saw it, was if it's solely dealing with those things, with ammunitions, with firearms, law-abiding citizens, those were the issues. If it's solely, so if they're just getting guns, if they're just seizing guns, that's where I read it. If it was somebody got stopped for another federal violation and guns were involved in that, that could still be brought in. That's how I read the law, just so you're aware how I interpreted it. But I think it's a good bill. It fixes some of the problems. Some of you were here in 22, some of you weren't. I spoke very strongly against the bill that we passed because I saw that it had problems. I believe this bill fixes it. It fixes it in a fashion that makes it to where everybody is protected, and it actually has some additional remedies that are available to citizens should their rights be violated. So with that, I'd take any questions, Mr. Chair.
Questions for Representative Wharf? All right, I'm going to ask you some questions. So you and I both interpreted the law in our initial reading the same. I have spent some time with legal staff. They disagree. I think the drafter of the bill disagrees that it actually has to do with the laws that are being enforced. So in talking to the legal staff, if you have a copy of the bill in front of you, to accomplish what how you and I interpreted it, the word solely would need to be either added or moved to line 18. And that would be attempt to solely enforce.
What page, Mr. Chair?
I'm sorry, page 3.
Okay.
Line 18. Or an attempt to enforce, the word solely would have to be applying up here. And I get that. And in my conversations with my sheriff, that was why I felt like the amendment was unnecessary. I still think the amendment is unnecessary based on the law, as long as we don't get our agents caught up in the prosecution. I think the law, this bill is written, does not do that because of the exception and because of the lanes, if you will, where we can enforce state law. Earlier it was I think Representative Smith asked about being able to sue the federal government. I just want everybody and the public to understand. I think you still can sue the federal government, but it would be under the Federal Civil Rights Act is how you would accomplish that. So,
Correct.
other than that, there is one concern I would have, and I want you, Representative Wharf, to kind of give me your thoughts on this, and that would be the issue of incarcerated individuals using this as an opportunity to just lawsuit after lawsuit after lawsuit, which would cost the state, cost the county, whoever's being sued, substantial money. I don't think the individual's going to get any money. I think it's all going to go to attorneys. But it could be cumbersome. As you look at this bill as it's written, do you foresee any potential friendly sideboards that could be put on without violating an individual's civil rights that is incarcerated, to where we could avoid unnecessary and frivolous lawsuits from incarcerated individuals against, using this bill?
Well, Mr. Chairman, that is one of the problems with our system, and our system allows people to bring lawsuits all the time. And I know, to me, I don't see that being a problem. It doesn't deal with anything back. It only would apply when this becomes enacted.
Agreed.
And so I look at it, if somebody's had their rights violated at the time, yeah, they should be suing. But it isn't something that I think you're gonna have a bunch of people that get incarcerated and they do a bunch of research, saying, oh, we can file a lawsuit. Because I don't see that in the bill. I think it's tight, and I think it's very clear when it's applicable and when it's not. And so I guess I don't worry about that. And I hate to say it, but I know in law enforcement, that's one thing you're just accustomed to, is you're gonna get sued. I mean, that's just a given. But I know when I talked to my sheriff, because I talked to my sheriff and I asked him if he had any issues, and his response to me was, none at all. He said, I don't plan on having any policies that violate the citizens' constitutional rights. And so that's the safety net that I have. I look back, and if you'll indulge this is a little off topic, but we were dealing with wolf issues in Sublette County, and they were having wolves that were hanging around a bus stop. And the people were concerned, and they said, what would happen should we have to shoot a wolf because we were worried it's going to hurt our kids? And the sheriff told them, my obligation is to tell you that the first thing you would have to do is call the U.S. Fish and Wildlife Service and tell them that you shot a wolf. But he said, keep in mind, it will be investigated, just like it was a murder. They will come in and do a full audit, forensic audit, looking at it, and making sure that your story aligns. But he said, your second call needs to be to me, because my duty and obligation changes as the sheriff representing this county. It's to protect your rights and ensure that they're not violated by the government when they come in and do this investigation. And so that's changed the way I see things. I believe that the sheriff understands, my sheriff I know understands this, and I think that's the clarity that people need to have on the committee, is all this is saying is don't let the feds come in here and violate somebody's constitutional rights in regards to the Second Amendment. That's what this is doing, is it's making it clear if they try to get our guys to do something that does not align with Wyoming laws, our guys don't need to help them enforce federal laws. They're not obligated to do that. They are obligated to protect us against overreach federal government. That's what this bill does.
All right. Any questions for Representative Ward? Representative Sherwood?
Thank you. So prior to this, right? Can a Wyoming law enforcement officer who is faced with that scenario say thanks but no thanks? I'm not doing that. That violates the Wyoming Constitution. Without this law, can an officer say, nope, not gonna kick in that door, nope, not gonna violate that person's right?
Mr. Chairman, Representative Sherwood,
Representative Ward?
I would imagine that you could do that, but you probably would do that at the peril of your job. Because if your supervisor is telling you to go do something, you got that's your option. You either do what you're told or you risk losing your job. And to me, that's what this is protecting. This is protecting our guys from being forced into a situation where they're told you have to go do something that you don't want to do, that violates Second Amendment rights. It is very expressly directed at that. So what it does to me, this protects law enforcement guys. It protects them from being obligated to follow a policy that is not in line with the Constitution. And so to me, that's what this is doing, is it's just making it clear. And that's why we fought so hard to make sure that it's not the individual. And that's what needs to be clear. It's not on the individual officer. I don't blame the guys. If their boss tells them the policy is you do this, that's their option. You either do your job or you get fired. And what I want to do is I want to stop my friends in law enforcement from being obligated to do something that violates Wyoming's Constitution. And I think our Constitution is way more clear than the US Constitution. And so I do look at that. This is an added protection, not only for me as a citizen, but for my friends that are in law enforcement. They don't get in a situation like that where they're given an order that forces them to either violate the Constitution or lose their job.
Follow up, Representative Sherwood.
Thank you. And I appreciate the really thoughtful conversation around this complex topic. Do we know of instances in Wyoming where agency leadership has given a directive that is in conflict with Wyoming's Constitution? Is that happening?
Representative Ward?
Mr. Chairman, Representative Sherwood, I have no evidence that it's happening now, but I don't want it to happen. And I know it's happened in other states when they have been obligated to go help do things, to me, that shouldn't have been done. Now, not everybody has a constitution that we have. Our verbiage is very clear in our Second Amendment. So, but I do think this is more preemptive. It's to make sure that we don't have any of these problems.
Follow up? All right. Representative Angelos.
Thank you, Mr. Chairman. Representative, just a quick question. Has this law, this exact one with civil penalties, been passed in other states?
Representative Ward?
Mr. Chairman, it has. It probably, the one I'm most familiar with is Missouri, and if you would indulge me, Aaron can probably address that better than me, but I know it has been challenged, but I believe he has an answer to that. If
Mr. Dorr?
Mr. Chairman, members of the committee, this bill most closely resembles what Missouri did in 2021. That law was challenged by the Biden White House and DOJ. It was struck down in the Eighth Circuit. It's really important to know that in their opinion, they clarified multiple times, there is no problem with the state not helping enforce federal law. Their issue was in the preamble, and they found words that they thought were a supremacy clause violation. What other states are doing right now, including Missouri, and what this bill will also do then is remove problematic words that the court had issues with in a best effort to pass a version that will survive court scrutiny.
Does that answer your question?
Representative Angelos.
Thank you. Yes, it does clarify. I guess my other question would be, do you feel that the current SABA bill that we have, SABA law that we have on our books does not protect our law enforcement agency? If this one does that, does the one that we currently have, does it not protect them?
Representative Ward.
Mr. Chairman, I think this improves the current statute. And I just believe, and I know when we passed it, this was in the bill that we tried to pass. And I know when we passed the bill in '22, I voted against it because I saw that it had problems. And I believe that this bill pulls it all together where it doesn't undermine our current statute. I think it's complementary and I think it's additive. And I think that's what this does. It just gives more tools and more protection to us as citizens.
Okay. Mr. Dorr, the friendly amendment, I believe it's friendly, that's coming with severability clause, does that help with the situation you saw in the Missouri bill?
I don't think it would help the Missouri problem. That problem was more about supremacy issues, but I think it'd be excellent to have that clause added to this bill, Mr.
And
Chairman.
that's considered friendly?
I'm sorry?
That's considered friendly?
Yes, sir, it is.
Okay, I have another technical correction. If I have a copy of your friendly amendment, I haven't seen if it's in this, but there is a technical issue on page 9, line 4. We need to get the word including changed to just include. Strike ing, replace with e. Just a small thing. So let's make sure if we're bringing that amendment, we get that included in there. Okay, all right. Thank you, gentlemen. All right, we're gonna start with agencies now. So I'm gonna bring up the law enforcement gentleman first, and if you'd like to bring your lobbyist with you, we can bring Mr. Thompson up as well. All three of you can come up. And we're gonna go to online after these gentlemen, so we'll start working on the online testimony after this. So I want to get a good amount of testimony on this before we take this to the floor. So I'm going to give, there's three of you. If you're all going to speak, I'll give you 5 minutes each. If you can keep your remarks within a 5-minute period and just let us know where we're at on this bill from your perspective, we'd appreciate it. And so let's just go with Mr. Thompson first, and when we get to you, gentlemen, if you could introduce yourself to the committee and the public, and give us all your thoughts on this bill. Mr. Thompson.
Thank you, Mr. Chairman. My name is Alan Thompson, the Executive Director of WASCOP, the Wyoming Association of Sheriffs and Chiefs of Police. I do want to, just based on some testimony this morning before I get into my prepared testimony, answer a couple of questions. I just want to say that it's difficult to separate state and federal gun law and the daily activities of law enforcement. A deputy could stop a car for speeding and then learn the driver has a warrant issued by the Bureau of Alcohol, Tobacco, and Firearms for a federal firearm violation. Officers are not always told what the underlying charge is, just that the person is wanted and that is the person that is wanted. And the issuance of the federal government warrant isn't necessarily going to say what agency or what the underlying charge was, just that it was issued by the U.S. Attorney's Office. And that could put law enforcement into providing material aid. So there's just instances like that we have to work through should this law pass, that help us make sure that we comply with it. And it is not it's not just clear. It's going to take a lot of study and a lot of understanding of it. The criminal penalty in existing law was for violating very different language. So the change in the language of the bill and then the continuation of the criminal penalty is somewhat different in that the bill is different as it exists today. If this bill passes, that would be another point that we would have to study and make sure that we were complying with, because that risk is for the agency on the liability front and then for the individual on the criminal front. We understand the intent of this bill, and it's to provide law enforcement or prohibit law enforcement from seizing firearms. There's a question about what a law-abiding citizen is, because every person later convicted of a heinous criminal act was at one point a law-abiding citizen. And there's, I think, some language in there that helps us with Wyoming gun law and seizures and all that stuff on page 8. The Senate amended page 8, line 4, to allow for Wyoming law enforcement to enforce Wyoming gun laws and continue to seize firearms in criminal investigations. However, page 5, line 1, still prohibits Wyoming law enforcement from seizing firearms when acting under the color of state law. It says state and federal law on that page. And I would just ask the committee to consider, if we're trying to focus on federal gun law, then we should be looking at acting under the color of federal law. And I think that use of the word state law in that sentence calls into question that page 8 exemption. I think they might be a conflict.
All right. And I think that was in your amendment. I recall the word state being stricken there. We're going to get some more testimony on that from both sides of the issue, because that may or may not be a valid point. So want to get to the bottom of that. Any questions for Mr. Thompson? Okay.
Mr. Chairman, I did have one other amendment, if I
Go
could.
ahead.
Thank you, Mr. Chairman. On page 6, it's purported to abolish task forces. But what it does is call into question the hiring of anyone that previously worked for the federal government, including military veterans. From a purely risk management standpoint, if I'm looking at applicants that do have federal law enforcement experience or federal employment experience, and those that don't, from a risk management standpoint, I might choose the one that doesn't. So if I have 10 employees, 4 of which are veterans, and one seizes a firearm that is later found to be in violation of this law, the agency liability, I heard some testimony that it is limited to one instance, but I don't know that it's clear in that language. I think that there could be an argument that we have 4 employees and that liability attaches 4 times. And then you still have the criminal and civil liability found on the other pages. The initial part of this bill prohibits any employee from doing this. And then it goes on to say there's also a violation if the person was a former federal employee. If we're looking at prohibiting this activity and making agencies liable, it's covered under the first section. I think all of page 6 just calls into question if the language or if the intent of that was to prohibit task forces. There's nothing in that page that says that Wyoming law enforcement can engage in task force activity. I think either amending that page 6 out entirely or clarifying that to prohibit law enforcement from engaging in federal gun task force activity would be better than capturing veterans, capturing people that worked for TSA, people that worked in any facet of federal government would be then included on that page. And I think I understand the intent from the testimony that we heard this morning, but I think it is a very, very wide net. And so my request for the committee is to consider just deleting page 6, because the liability and the criminal penalty still attach elsewhere if that same exact thing happens. And that's all I have, Mr. Chairman. I'd be happy to answer any questions.
Mr. Thompson, I saw the delete page 6 in your proposed amendment, and I felt it was unnecessary, and it's actually getting at the meat of the bill. And the meat of the bill is where I see, enforcers or attempts on these task forces. And I felt like the language on line 16 and also on line 22 and 23 gives the exemption that is necessary, and that is solely regarding firearms, accessories, and ammunition. And again, that solely is applying to the verb participates. So if they participate in a task force that solely is regarding firearms, accessories, and ammunition, then they are in violation. But if it's not solely regarding that, then they are not in violation. I don't know about the word previously on line 4 and the employees. Maybe there's a need to tighten that up so the intent is clear. I'm not sure. And I do have our legal staff looking into that. I'm open to suggestions from you. But me personally, I think that if you strike page 6, you basically make this bill ineffective. So.
I understand, Mr. Chairman, and if I could offer one more consideration on that.
Please.
On page 6, line 4 and 5, if you tightened up that definition by indicating with arrest powers, most of your military or TSA or, I mean, if you're trying to get at that term that I heard for the first time today, badge swapping, adding language about arrest powers might tighten that up a little bit.
Okay.
Thank you, Mr. Chairman. That's all I have.
All right. Sir, welcome to House Appropriations. Please introduce yourself.
Mr. Chairman, members, good morning. I am David Janes, a captain with Cheyenne Police Department. I've been with Cheyenne Police Department for 21 years. I did want to offer some testimony and clear up a few things. One being that I've never heard the term badge swapping either. But let me explain what our task force officers do. We do have a DEA task force. We have officers that are sworn with the DEA. They are still Cheyenne police officers. They still fall under the policies. Our MOU with the DEA says that they have to follow the policies of the Cheyenne Police Department, but they work with the DEA. We also have a U.S. Marshal task force officer that works with U.S. Marshals. In fact, I spoke with the interim U.S. Marshal recently, and he clarified with me that they only have 9 agents in the entire state of Wyoming. And so this is what happens in a place like Wyoming, where we're very low population, is the federal government can't get any of their work done without our help. They're useless without our help when it comes to it. So when we look at the DEA, our task force has done amazing things. I mean, they've handed down indictments to cartel members and cartel leaders all the way on the other side of the border. Their involvement in the DEA allows them to go to Denver to do follow-up, allows them to put trackers on cars and follow them all the way into Colorado, to Greeley, Denver, Loveland, Fort Collins, these places where we can better keep this flow of fentanyl from getting into Wyoming. And our concern is that as soon as we pass something like this, which I appreciate the bringers of the bill on this one, because it is one of those things, I'm a firearms instructor, an armorer. I build my children guns. That's what they get when they turn 12. I build them a custom hunting rifle. My dad was a competition shooter and a 41-year law enforcement officer. I won our Second Amendment rights. I think it's extremely valuable to us. My concern is, one, when I hear people speak on behalf of the line officers. I've spoken to a ton of line officers, and what I keep hearing is that they feel attacked and villainized for doing their job when it comes to this sort of thing. And so we need to be careful with that, because we want them to be able to do their job. And so as far as the agency, when we start looking at this and we evaluate our ability to be part of these task forces, our ability to go above and beyond, are we willing to take the chance? Because the word solely and the word arguably came out of the attorneys. If it's arguably going to put us at liability to be part of these task forces because we don't have control on how the attorney or the U.S. attorney prosecutes these people contacted by our officers, we won't cooperate or be part of these task forces, and it will severely limit our ability to prevent these things going into Wyoming. We're talking about the ICE and the enforcement of federal immigration law. What is the chance that during one of these task forces, we end up contacting a Wyoming resident and they're found in violation of federal prohibited offender laws, whether it be a prohibited domestic violence offender or a nonviolent felony, which is substantially different. The bill talks about enforcing laws that are substantially different than Wyoming laws. Many of the prohibited offender laws are substantially different at the federal level, but they also have a much better, the sentencing guidelines are much better, and we can keep those criminals in jail longer and off our streets longer to help us prevent crime. And so, like I said, as I'll be the first one on your doorstep to arrest a federal agent who is there violating your rights. Our officers will be the first ones there. We are already held accountable, as was brought up. It's been a long time, 1983 claims, if we violate your Second Amendment rights, you can sue the officer and you can sue the department. Absolutely, and please do. That's what the 1983 claims are there for. You can get a lot more than $50,000 if your rights are violated. And so I want to say that there's already a lot of stuff in place. I am a little frustrated with the fact that multiple times the bringer of the bill said that he wanted to make sure that we weren't enforcing unconstitutional laws, but the word unconstitutional was taken out of this bill. That's the frustrating part to me, is that's a very clear definition. Our officers swore an oath to not enforce any unconstitutional laws, but we're going to take that word out of this bill, meaning that we want to criminally prosecute our officers and civil liability on departments for enforcing already deemed constitutional laws at the federal level. That makes it unclear. When it says unconstitutional, it's very clear. You're saying you're going to uphold your oath and you're going to enforce constitutional laws, and you are not going to enforce unconstitutional laws. So, like I said, while I'm very happy that people are talking about the Second Amendment and that we want to protect it and we don't want to be like our neighbors to the south and make laws that are completely unconstitutional, I think it's important that we support our law enforcement in their endeavors in trying to keep these horrible things from coming to Wyoming and happening in our communities. So, and I stand for any questions.
Questions for Captain James? I have several.
Yeah.
So I thank you for your testimony. I do appreciate you being here, and I really appreciate your comments about standing up for your constituents' Second Amendment rights and being the first there to stop those federal agents that might be in violating those for our citizens. So that is the point of this law, is to maybe give people like yourself, one more reason to not help those feds do that. But here we are, and we're looking at it, and I made some notes during your testimony. You said arguably. Is that in the bill? Because I haven't noticed that word in the bill.
Mr. Chairman, I was referring to the attorney who was speaking about whether it applied solely to those crimes. If you're only looking at, and if it's arguably there, a plaintiff's attorney will jump on the chance to file a lawsuit.
Agreed, Captain James, and that's why I'm working on that word solely. And both myself and Representative Worf interpreted this the same, which wasn't what the drafter of the bill intended. So I think we have a little bit of work to do there, but we'll get that, I think, lined out. So the arguably, we need to clear that up. I agree with you. You also brought up a point of federal statutes being better than ours, or the only statutes that could be enforced in some things. And I know we heard testimony in this committee about money laundering. The state of Wyoming has really no statutes on the books for money laundering. And so, we've enforced federal law when it comes to that issue. So I agree, there's probably some laws out there that wouldn't be substantially along the lines of Wyoming law. So I think that needs to be looked at as well. You're right, we need to try to clean that language up and ensure that we're not putting you in a situation where you can't enforce those laws that the state of Wyoming just either has insufficient coverage or no coverage whatsoever. But I think that's doable. We can address that. So I appreciate you bringing that point up. You mentioned unconstitutional. I do believe this bill doesn't have that, but the act that it's applying to, I believe, does. So we need to clarify that. And I'll just ask the drafter and the representative who's going to handle this bill if I'm correct about that. And if that's the case, I think you're still in good shape as far as unconstitutional. If not, we'll address that as well. So thank you for bringing that point up. Any additional comments since I've...
No, Mr. Chairman, just in case, it is page 3, line 20 is where the word unconstitutional was struck. And thank you.
It was struck from there?
Yes.
Oh, I see it now.
Mr. Chairman, if you don't
Representative
mind.
Harrelson.
Thank you, Mr. Chairman. Thank you for coming today, and I appreciate. One of the things I want to just make very clear, we are very blessed in Wyoming to have the law enforcement we do. I think all of us could say that across the board. But one of the things you said that I want to kind of zone in on is we've seen some things happen in the United States that scratch our heads and go, that isn't constitutional. Just as much as I would hope our sheriffs stand up and say, whoa, wait a second, you passed a law that's not constitutional. We can't uphold that because we took an oath, right? And so my question would be this, because I understand your angst and your frustration, and I don't think, and I need to apologize if you've ever felt that us as the legislatures have villainized you guys in this, because I don't think that's the case. But there is a point where we want to protect you guys and protect the system and protect the people. And so do you believe if we were to work through these issues that you could sit there and go, yeah, we can see that as them upholding and protecting us, but yet at the same time upholding and protecting the people? Can you see that kind of where we're trying to go with that?
Captain James?
Mr. Chairman, through you. Yeah, our biggest thing is I want our officers to go out there and be completely clear that they are upholding their oath. And I want them to be protected from administrators who may not allow them to do so. And fortunately in Wyoming, in Cheyenne, we have a civil service commission. So when you talked about an order telling them to violate someone's constitution, them getting fired, well, they're protected from that already because it has to be at cause. It'll then go to the Civil Service Commission. The officer will get their job back, and I think they will have a very good lawsuit at that point. So, I feel like they are protected already, and we're protected already. And I am okay with any bill that says you need to fulfill your oath, and you're protected if you fulfill your oath to enforce constitutional laws and to not violate people's rights. And I appreciate that, and that's why taking the term unconstitutional out really kind of rubs me and a lot of the officers I work with the wrong way, because it is, I want clear instructions to our officers. You are to uphold the Constitution, and you're expected to uphold the Constitution. If someone tells you not to uphold the Constitution, you're expected to say, no, I'm not going to do that. And I think they need to have the freedom to do that.
I want to go back to this word unconstitutional since we're debating this right now. And I can foresee, in my opinion, and I think there's probably legal scholars out there that would agree that the National Firearms Act is unconstitutional. And so, we come into this, by having the word unconstitutional in there, we could really come into some interpretational issues. And I think the intent of the bill without the word constitutional or having it struck is probably that we just don't want you to enforce any federal gun laws. What are your thoughts on that? And are you capable of performing your job without enforcing any federal laws? The intent of the drafter was to create lanes where you can enforce all state laws, and maybe the word state, as brought by Mr. Thompson, is an issue, but as long as you stay in the lane of enforcing state gun laws and not federal gun laws, then this bill would work. Are you capable of doing that?
Yeah. Mr. Chairman, first of all, I agree with you on the NFA, and I'm really looking forward to some suppressor legislation coming out. As I love my suppressor, but I'd like to get more and have them more affordable. But as we talk about, especially our task forces and the chance that they might contact someone and then the U.S. attorney charge them, I think about domestic violence offenders. It's not against law in Wyoming to possess a firearm as a domestic violence offender. It is against the law federally to possess a firearm as a domestic violence offender. And if they charge that, now we have provided material aid because we've provided the officers as part of the task force, even though they had nothing to do with the charging and nothing to do with it moving forward from there. Now we've exposed ourselves to this liability. So I do think it makes it really difficult for us to participate on any of those actions to help keep those things out of our state, which is, it really does a lot of good work for the state of Wyoming as it goes. But again, it's so much of this has become, like the attorney said, arguable. We appreciate the intent, and we know that the intent is there to make sure that our officers are protecting people's rights and that they are not doing anything unconstitutional. But they need that clear to them as it goes. And adding the criminal charge back to public officers, I think then muddies the waters on, are we looking at agencies or are we looking at individual officers?
So Captain James, neither you nor I are probably have a legal degree or have spent a lot of, well, you probably have spent more time than I in dealing with the courts and attorneys. But you heard Representative Worf and I in our interpretation, and I just want to walk you through some potentially different language that would, I believe, actually protect you from what we just discussed. And that is if we apply the word solely on line 18 of page 3. So, and we're talking about task force here. So if we start up at, at page 3, line 17, or any federal funds or other source of funds to enforce, attempt to enforce. Now, if we were to insert the word solely before the word enforce on line 17. So any federal funds or other source of funds to solely enforce, attempt to solely enforce, provide material aid, support, participate in any other enforcement, or maybe we could even put it in front of the word enforcement, in any manner in the sole enforcement or implementation of any act, law, treaty, so on and so forth, and then regarding firearms, accessories, or ammunition against the law enforcement. So then the word solely is talking about your work in enforcing, rather than what the prosecutor does after the fact. Does that make sense to you?
Yeah. Mr. Chairman, I think that's a fantastic fix on this, because then it allows us to say, yeah, we don't agree with a lot of the federal rules, we don't agree with, and we're not going to only do that. You know, we will help investigate your narcotics things going on. We'll look for those burglary warrants with the U.S. Marshal Task Force. We'll do these things. Those are different. If they choose to do what they're doing as on it, I think that really helps us to say, you know, ATF, we're not going to go kicking doors, you know, which we would tell them that anyway.
So Captain James, and let's just bring this into the conversation that, you know, many times enforcing some of these other issues, which we want you to, that you've testified, it's critical to the state of Wyoming that we can do these drug enforcement issues, these ICE issues, and we want you on the ICE issues, believe me. We're trying to find a solution where you can work with ICE. You know, all these task forces where you are working to deal with these, but they all end up, many of them end up, probably over 90% of them end up with firearms issues. So we want you to be able to deal with those firearms issues. You know, we don't want you to say, well, this DEA task force, we might end up with a gun issue, so we can't join that task force. And I think that the bill actually allows for that with the exceptions. But the word solely means that you would not join a task force with the DEA if the DEA was only going to go enforce federal gun laws. If we changed the word solely to deal with your work in enforcing, rather than the prosecutor's work in applying the federal laws. And maybe we can do both, but at least going into it, you would know you can make an agreement to join a task force without violating this law, because you're joining a task force that is not solely addressing firearms and ammunition. Is that clear as mud, or did I help?
Mr. Chairman, that would really clear it up, and in fact, that's language we would then put directly into our MOU. And so it would help protect both us and both the agency and the officers in participation.
Okay. And I think that's what came out of my conversation with my sheriff, and I think that's the way Representative Worf interpreted it. Don't want to put words in his mouth, but I think there's a fix here. But we'll have to find out from the drafter, you know, do we want to remove that issue with the federal law? You know, I don't know that we have to, if we can at least address your ability to join a task force that doesn't solely go after firearms. Okay? Any further questions for Captain James? All right, moving on. Thank you, sir.
Good morning, Mr. Chairman, members of the committee. My name is Carl Tremaine. I'm a Lieutenant Colonel with the Wyoming Highway Patrol. Thank you for letting me testify today. I just would like to point out a few other scenarios that we deal with here in Wyoming, particularly with the Wyoming Highway Patrol. I'll start by saying first, I understand the intent of this bill. I'm pro-United States Constitution. I've taken an oath to defend it. I'm pro-Second Amendment. I'm a firearms enthusiast. And anything we can do to bolster the protections of our citizens, I agree with. Some of the concerns that have been brought forward today are concerns that I also share that aid in confusion to our Wyoming law enforcement officers should this bill pass. In the Wyoming Highway Patrol, we do have members on various task force to include ICE, U.S. Marshals, and at times the DEA. But the federal agency that I'd like to draw your attention to, Mr. Chairman, is the BIA, Bureau of Indian Affairs. And so we do have troopers if you live or a patrol on or where the reservation crosses over on state highways, and we will send those officers to become BIA certified. Without that certification, if they happen to stop a Wyoming citizen who is a member of a Shoshone or Arapaho tribe, we can't enforce any law on that person. So with the BIA certification, that allows us to enforce federal law and work with the U.S. Attorney to bring charges against that person should it be needed. And there is also a pathway with that certification to have federal law adopt state law, but sometimes it isn't always black and white. And so a good example of what I've experienced, because I patrolled in that area, I myself was BIA certified. Without that certification, if I stop a member who is, again, a Wyoming citizen, but they are a member of the Arapaho Nation for the purpose of this conversation, and say they are under the influence of alcohol, I can't do anything with that person. I have to wait until a BIA officer can arrive on scene. And sometimes that can be hours given their staffing shortages and vast distance up in that region. Now, if I am BIA certified, that allows me to go ahead and process the arrest, and let's just say during the course of that DUI, I discover a gun charge. I could charge that person with whatever the charge happens to be underneath federal law. And the way that I interpret this bill and the way that I've heard it interpreted is it may not be solely the reason why I'm stopping that a person, but it would give me cause or pause to do my job should this bill go into effect. And so that's the point that I'm trying to make is there is a complexity issue with a state citizen that is a member of a tribe nation that we would be enforcing federal law on, and we don't have necessarily the ability to enforce state law without this certification. And it would cause us to second guess whether we put officers, the way it's currently written, into the BIA certification program. However, I do think possibly with your amendments, Mr. Chairman, that you've spoken about today, that if I see that language, then there could be a pathway forward for that. The other point that I would like to make is, I've heard possibly conflicting testimony about this is about the agency, but then we'd still have the criminal charge in there that is against the officer. In previous testimony, I had also heard language mentioned that the line officers are in support of this bill, and I personally haven't heard that from any of our troopers. I did check with our Wyoming Highway Patrol Association, and they hadn't heard anything from the members other than what they relayed to me was that they had some reservation with the current language that was in the bill. And with that, Mr. Chairman, I'll stand for questions.
Well, Mr. Germain, thank you, Officer Germain, thank you for being here. And you bring up some excellent points, something that I don't think this committee was probably aware of, this BIA certification. And I do believe that the way it's written, you would be in violation if you tried to enforce a federal gun charge on that individual with a DUI. So we're going to try to fix that. But let me ask you this. Since you're kind of wearing two badges in that situation where you're BIA certified, would you, in your opinion, be able to enforce a state gun law on that individual and preclude yourself from enforcing a federal gun law, even though you're using your BIA certification because of the individual that you're arresting?
without the BI certification, you can't enforce any state law against a tribe member. And so that's the purpose of having the BI certification. Now, there are some ways that the state laws can be adopted through federal law, but the prosecutor still has to be willing to charge that, and that's up to him or her whether they want to go after that individual with a federal law or a state law. The BIA is a very complex situation, and another example of this, Mr. Chairman, is without the BIA certification, say you see a car going 100 miles an hour in a 45-mile-an-hour zone. If you walk up to that car and find out that they are a member of that tribe, you can't cite them. You can give them a tribal citation, but that's an agreement that we have with the tribe, but we cannot write them a state statute.
Thank you for that clarification. I'm gonna go back to it though, just a little bit. Do you have any, as a BIA certified officer, do you have any leeway, any authority to ensure that you're enforcing a state gun law versus a federal gun law, should you find a gun issue besides whatever else you may have pulled them over for?
I'm going to say that that's up to the prosecutor. I mean, the last thing that I would want, Mr. Chairman, would be for a trooper or any officer that happens to be a BIA certified to have to try to work through that roadside. I would want them to address the crime in hand and not worry about being charged or if the agency is going to be sued because of actions taken.
Okay, and one last question for me, and then I'll open it up to the committee here, but in that situation where a BIA officer has pulled over a tribal member, what kind of prosecutor would that go to, or do you have, is that just based on jurisdiction?
It would go to the U.S. attorney up in the area.
So we could pretty much assume that it's going to be a federal law that's going to be charged if there was a gun violation.
Absolutely, Mr. Chairman. It would most likely be a federal gun charge.
Okay, thank you. Questions for the officer, Germain? Guess I've covered it pretty well. Thank you very much for being here. Ms. Childress, we were going to go to online next. I don't know if you've been able to communicate. We're running out of time. So if you've been able to communicate with those people that are online, we'd like them to come back. We're going to continue this bill at our next scheduled meeting. Today it's morning, so it'll be noon tomorrow on our noon recess on Wednesday. So we're going to continue this bill at that time. Is there anyone else in the room that came to testify on this bill before I close this meeting out? Okay. Seeing none, we're going to adjourn, and we're going to continue this discussion on Wednesday noon recess for this bill here. All right? Any objections? Seeing none, we're adjourned. Thank you.